Excellent. Well, we'll wait for Mr. Fallon to join us. Do you know what's holding him up by any chance, Ms. LaBelle?
I think he may have gotten the mistaken address, Zoom address. So I've just sent it to him.
Okay. We're presently live streaming on the YouTube, Mass DEP's YouTube channel, just to let you know.
Thank you. I think that's great.
Now there's admit. Someone needs to come in. All right. We're waiting for Mr. Fallon, gentlemen. Once he arrives, we'll start.
May I ask a question?
Yep.
What does streaming live on YouTube mean?
It means that people who are not present in the Zoom can watch it on Mass DEP's YouTube channel. There's a significant interest in this case internally by Mass DEP staff, and having them all have Zoom links would not be practical. So it's basically Zoom plus. I see Marilyn Levinson has joined us. Ms. Levinson, are you there?
Yes, I'm here. I'm just waiting for Mr. Fallon to join. We're just having
Looks
a little
like
technical
he has
difficulty.
entered. Someone can let him in?
Yep.
Okay.
He's connecting. I'm gonna turn off my video.
Okay. Mr. Fallon, your video is not on. Oh,
Yeah,
there you
great.
are, Mr. Fallon.
Thank you.
Good.
Thank you. I apologize for the delay getting in. Good
No,
morning,
no.
everyone.
No, good morning. No apologies necessary. Just that you know, Mr. Fallon, your camera's off. All right. All right. Just that you know, this proceeding is being recorded. It's also on Zoom, and it's also being live streamed on Mass DEP's YouTube channel. I think you're aware of that because, because of what you did in Algonquin, because that was also live streamed. All right. And so with that being said, let me just repeat again that this proceeding today is being recorded and is also being live streamed on Mass DEP's YouTube channel in addition to Zoom. In any event, let's get started. It's past 10 o'clock. My name is Salvatore Girlandino. I am the Chief Presiding Officer of Mass DEP's Office of Appeals and Dispute Resolution. With me today from the Appeals Office are Doreen Kearney, who is the Interim Case Administrator for the Appeals Office, and Joseph Furson, who is the Interim Assistant Case Administrator for the Appeals Office. Both Ms. Kearney and Mr. Furson are assisting me in the technical part of conducting this proceeding via Zoom and through live stream on Mass DEP's YouTube channel. In fact, Mr. Furson probably soon will be shutting off his camera, but please note he is still there and he will troubleshoot any issues should there arise technologically during this hearing today. What's scheduled for today is oral argument by legal counsel who represent the parties in the pending administrative appeal known as in the matter of Palmer Renewable Energy, LLC. And throughout today's proceeding, I'll refer to Palmer Renewable Energy, LLC as PRE, the acronym that it's known by. Will counsel who represent the parties please identify themselves for the record, beginning with Mass DEP?
I'm sure. Good morning, everyone. My name is Macdara Fallon. I represent Mass DEP in this matter. There are several people in the room with me. Would you like me to introduce who's here?
Yes, please, because we'll be for the record, please.
present in the room with me are OGC counsel, Lauren Karen, Bruce Hopper, Marilyn Levinson, and Benjamin Meshulam. I apologize, I had to ask Benny how to pronounce his last name. They are present with me in the room right now.
Sure. And I believe you already mentioned that Ms. Levinson and Ms. LaBelle are with you today?
I believe Christine LaBelle is watching on the YouTube
Yes.
channel.
I'm
And
actually
I
on the Zoom as well.
Yep.
Oh, Christine LaBelle as well.
Yeah.
Thank you.
And Ms. Levinson did identify herself earlier. I know she's on Zoom as well. Her camera's not on. And so, Mr. Fallon, will you be principally arguing for Mass DEP, or will you be sharing time with your colleagues?
I will be principally arguing. If you have questions that I am not able to answer directly, I may ask my colleagues to assist in answering those questions.
Sure. I will discuss that when we get to the format of how we're going to proceed after I have counsel for PRE identify themselves. Will counsel for PRE identify themselves for the record?
Sure. My name is Thomas Mackey. I'm a partner with the law firm of Mackey, Shea, Durning in Boston. We represent and have represented PRE since the initial application for the initial permit in this case. And I'm also here with, I will be doing the presentation for PRE.
Okay.
I'm
And I
accompanied by
noticed
Peter.
Oh, go ahead. I'm sorry.
I'll let Peter Durning introduce himself.
Sure.
Thank you, Tom. Peter Durning of Mackey Shea Durning, also on behalf of Palmer Renewable Energy, but I'll likely have my camera off as Tom is handling the presentation.
But we'll acknowledge that you're still part of the Zoom proceeding. Thank you for letting me know about your camera being off. Now, before we get into the oral arguments of legal counsel, it'd be good for the benefit of individuals who are watching this proceeding via Mass DEP's YouTube channel, what the nature of this appeal is about. In this appeal, PRE challenges a revocation order that Mass DEP's Western Regional Office in Springfield issued earlier this year on April 2nd, 2021, that revoked an air permit that Mass DEP's Springfield office issued to PRE almost 9 years earlier, authorizing PRE's construction and operation of a 35 megawatt biomass fired power plant at 1000 Page Boulevard, also known as 440 Caldwell Drive in Springfield. Mass DEP contends that it revoked PRE's air permit due to PRE's purported failure to commence construction of the proposed power plant within the 2-year period required by Mass DEP's air pollution regulations at 310 CMR 7.023K. And it's also Mass DEP's position that it correctly exercised its discretion in revoking the permit after making the determination that PRE purportedly did not commence construction within that 2-year period. Basically, the first question involves, was construction commenced within that 2-year period? And if so, did Mass DEP make the correct choice of revoking the permit? Because everyone agrees in this proceeding, and when I say everyone agrees, I mean the parties, that if DEP made that initial determination correctly, that DEP would have had a choice, either to keep the permit in place, revoke it, or as Mr. Mackey pointed out, I believe in your most recent brief, Mr. Mackey, correct me if I'm wrong, but it was somewhere that suspending the permit could have been another option. All right. And so basically, the second question is, did DEP correctly exercise its discretion? DEP also says or contends that it properly revoked the air permit as a result of relying on the Commonwealth's environmental justice policy, which has been promulgated by the Executive Office of Energy and Environmental Affairs, otherwise known as EEA. EEA's EJ policy is a policy that governs the regulatory actions of every single agency under EEA's jurisdiction, including Mass DEP. And it is a policy that requires every EEA agency to make environmental justice an integral part of their regulatory actions. And then the last, issue that's involved in this appeal is whether I should allow PRE to assert a brand new claim at this late stage of the appeal, specifically a claim that DEP's revocation of the permit was the product of illegal racial discrimination in violation of the Equal Protection Clause of both the 14th Amendment of the United States Constitution and the similar provision under the state constitution. So those are the issues that are here for argument by legal counsel for the parties. And the format that I'm going to use is that I'm going to ask questions based on these issues to counsel. And then after, to one of the parties' counsel. And then after that counsel concludes answering, I will go to the opposing counsel to give a rebuttal or, his or her client's take on that issue. And so, since Mass DEP has the burden of proof in this appeal, I believe that it's only appropriate that I lead off with my first question to Mr. Fallon. Mr. Fallon, tell me why Mass DEP thinks it made the correct determination that PRE did not commence, I'm going to paraphrase the regulation, commence construction within the 2-year period of 310 CMR, 2-year period of 310 CMR 7.023K. Please explain to me why DEP believes that its determination was correct.
Thank you, Presiding Officer Gerlandino, and thank you for the opportunity also to give oral argument on these questions. The department is very comfortable because the evidence is very clear that construction, as that term is defined under the regulations, has not commenced at this site. It didn't commence during the time period that the department first started looking into this stale permit from the Western Regional Office in March of 2019. It did not commence during the department's site visit on February 2nd, 2021. It did not, and it was certainly not ongoing when the department issued its revocation order.
Mr. Fallon, let me stop you right there, and because I will be interrupting as well. So tell me, when did the 2-year period actually begin? Because in one of the briefs that the department or Mass DEP filed, there was an argument that the 2-year period began on June 11th of 2012 when the permit was issued. Is that DEP's position?
No, and I don't believe that I would need to clarify that for you, Officer Gerlandino, because that is not the department's position. What that date represents is the issuance of the conditional permit that was subject to appeal. That document did not become final until after the adjudicatory proceeding, which resulted in a commissioner final decision being issued on September 11th, 2012. That's the date the permit came into existence for the purpose of both triggering the 702(3)(k) provision of construction to commence, as that term is defined under the regs, within a 2-year period. And that also incidentally triggers the date for whether or not the Permit Extension Act applies to this particular permit.
So remind me, and I apologize, remind me, when did the region issue the permit in the first instance, before it was appealed to the appeals office? When was that issued? Remind me.
I need to check my date. Officer Giuliano, I have it written down. I apologize for the.
That's okay.
I believe it was in June 2011.
Okay. And so on September of 2012, that's when the administrative appeal of the air permit concluded at DEP, with then Commissioner Kimmel's issuance of a final decision upholding the air permit. Am I right?
Yes, in this department's position, that is black letter law under Mass General Laws, Chapter 38, that the permit was not in existence until the issuance of the final decision by the commissioner. There was nothing that could have allowed any emission from any facility to happen until that permit issued under a commissioner final decision. So that is the triggering date.
So you're saying the 2-year period for PRE to commence construction of the proposed power plant began in September of 2012, when then Commissioner Kimmel issued a final decision upholding the air permit. Is that the, all right. Now, Mr. Fallon, and when I ask these questions, I don't want anyone to assume that I've made a judgment one way or another. It's for me to understand where the parties are coming from. But isn't that position really unfair? Because the appeal was, the air permit that became final as a result of then Commissioner Kimmel's final decision in September 2012 was appealed to Superior Court, right?
That's correct, yes.
So is it really fair to basically say that the permit began? I realize what Chapter 30A says. I'm talking practicality and the issue of fairness, because the issue of fairness has been raised by PRE. That, you know, Mr. Mackey will have his turn to explain why he feels his client wasn't treated fairly by DEP. But what I'm getting at, shouldn't the 2-year period really begin when all the court litigation involving the air permit ended?
Thank you for bringing up that point. And on the issue of fairness, I think if the department took the position that PRE could not commence construction of its facility the day after the final decision issued, in other words, that the permit was final during the pendency of the Superior Court action, they would claim that was very unfair because they went through an administrative process and they got a permit. We agreed with it. We said that permit was appropriate and they can go forward with it. Nothing the department did or said prevented PRE from starting construction of this facility the day after the final decision issued. Therefore, PRE made the decision not to go forward due to litigation risk at the outset of this proceeding. So on the question of fairness, if we took the opposite position and said that the permit was not final, despite the fact that we have final agency action and prohibited PRE from constructing until the Superior Court period was over, that would be unfair. PRE could make their choices based on what they thought their best situation was. They made their choices, but they were outside the parameter of the department's jurisdiction or how the department could control what happened. Also,
Mr. Fallon, not to interrupt you, I apologize for doing so. But, and then I'm gonna, unless you had anything more on this 2-year period, I was gonna go to Mr. Mackey to give his client's point of view on that time period. But correct me if I'm wrong, wasn't the Chapter 30A appeal in Superior Court of the final permit, wasn't that stayed for a period of time? And DEP was a party to that appeal, obviously, because it was a final decision of the department that was being appealed to Superior Court. My recollection of reviewing the Superior Court docket in that 30A appeal is that for a significant period of time, that litigation was stayed. And so if DEP agreed, I don't know the exact details of the stay, perhaps Mr. Mackey, who was part of that Superior Court appeal, can educate me. In fact, I'll be turning to you in a second to let me, to tell me about that. And so if it was stayed, I guess the point I'm getting at, shouldn't the date, if any, and again, this is not a determination by me, shouldn't the date be when the court litigation concluded? And I believe in the initial order that I issued in this case, I believe I said, or maybe the department may have said it in its revocation order, that as of March of 2019 or 2017, I forget which year, when the deadline to appeal to the appeals court, because as I recall the proceedings in the Chapter 30A appeal in Superior Court, there was a stay for an extended period of time, and then the judge in that case decided the case on the merits by issuing a judgment upholding the air permit, and that the petitioners, the parties who appealed the permit to the court in the first place, chose not to appeal to the appeals court thereafter. So where I'm getting at is that, shouldn't the 2-year period begin when the deadline to appeal to the appeals court expired? That's a question I'm throwing out.
Yes, and understood, and thank you. Again, the stay, I was not part of this period court proceeding, but the stay of that proceeding doesn't affect the department's position. I turn back to the question of fairness. Applicants many times have our permits appealed to Superior Court under Mass General Laws, Chapter 30A. The department's position is consistently under those permits, be it a wetland program or an air permit, that the applicant has the ability to commence their construction or commence their activity at their own risk. Primarily because in the wetland situation, permits are only valid for 3 years. And if there's a 30A appeal and we required a applicant to not do any activity until after the end of the Superior Court litigation, they would lose time on their project. Similarly, with the air permit, once the air permit doesn't have an end date, it goes on forever. There is no end date of an air permit. But once they get the permit from us, they are free to make the decision, in all fairness, whether or not to start construction based on litigation risk. It's not the department to decide when they should construct or what are the risks involved in constructing, whether or not they should go forward. Nothing prevents them from going forward. And we would like to point out there was no judicial order in this matter staying PRE from commencing construction. However, if we use the date of the Superior Court action and use the last date that the appeal could have been taken to the Mass Appeals Court from the 30A proceeding, they're still outside the 2-year period to commence construction. It's not a question of fairness. In all fairness, to your question, I understand that it's a question of choice. And the choice that was made here by PRE was not to construct for reasons known only to them. And they're not part of the department's consideration when reviewing these kind of regulations and when construction should commence, for the reasons that we cited in our brief.
Okay, I will come back to you in a minute, Mr. Fallon. I want to get Mr. Mackey's take on the question that I posed to Mr. Fallon, whether or not the department, Mass DEP, made the correct determination that PRE did not commence construction within the required 2-year period of 310 CMR 7.023K. And in your response, if you know why the Superior Court case was stayed and then what happened thereafter. But in any event, go ahead.
Sure. Good morning, and thank you very much, Mr. Girolandino, for running this oral argument the way you are, because you would have heard an hour and a half of me going on over the very long and tortured history of this project. I wanted to say also, I really anticipate that you will do a scholarly and very thorough job on this. I've read your decisions in other cases. I've read your papers that you've issued in this case, and they've been incredibly thorough, and I'm sure you're up to the task. I also wanted to thank Mr. Fallon and the department staff and attorneys for paying really close attention to this case. It's an important case. To those folks that are watching on YouTube, please don't judge the case based on the oral argument alone. What you're seeing today, we have a stack of paper that's probably about 3 inches thick, comprised of affidavits and pre-filed testimony from experts and clients that instruct why this decision should be overturned. Let me address the dates, and I may get a little mixed up here, but fundamentally, it was impossible for Palmer Renewable Energy to build the project because the city of Springfield had revoked the building permits for the project. And that was not, the building permits were not reinstated until the end of a land court case that resolved, that reinstated the building permits. So it was unlawful for Palmer Renewable to commence construction. It's not a question of fairness, it's a question of legality. And that's why the Superior Court case was stayed pending the outcome of the zoning case. That was agreed to not only by the department through the Attorney General's office, but also by the parties who initiated the revocation of the building permit in the first place. So all the parties agreed, the parties that agreed to that initiated the appeal of the DEP air plan approval, excuse me. So
not to interrupt you, Mr. Mackey. So if I'm understanding you correctly, final decision by then Commissioner Kimmel issues upholding the air permit. 30A appeal is filed of the final decision in Superior Court. Around the same time, the city of Springfield, or during the Chapter 30A litigation, the building permits that PRE had obtained were revoked. And that as a result, PRE, the department, and the appellants in the Superior Court 30A appeal agreed to stay the proceedings in the appeal, 30A appeal, until the litigation involving the building permits was resolved. Am I getting that correctly?
That's correct.
Okay, and so I think an argument can be made that the department acquiesced by agreeing to a stay. The department acquiesced. Would that be your position or PRE's position?
Well, certainly, I'm not sure if agreeing to the stay constitutes acquiescence. I can only say that it was unlawful for PRE to commence construction of the project because it didn't have building permits.
Right.
That there was a significant amount of overlap. The appellants or the parties to the building permit case, some of those parties were also parties to the air plan appeal. And they were often represented by the same counsel. The details escape me now, but it was essentially a full-scale attack on PRE's ability to proceed at all different levels. And we have detailed that extensively in the pre-filed testimony of Dr. Victor Gatto, who is the principal project developer for PRE, who was there during the entire time. There were multiple attacks on the PRE project. Not only were the building permits revoked, a special permit that had been issued by the Springfield City Council had been revoked. Even after the Palmer Renewable PRE prevailed in the land court on the reinstatement of the building permits, within the month, the same parties petitioned the Springfield Public Health Council to require a Chapter 111-143 noise and trade site assignment, and claiming that the project could not move forward without such a site assignment. It took a substantial period of time, extensive public hearings, including many of the environmental justice advocates that have been mentioned in the papers, before the Public Health Council ruled that Palmer Renewable Energy did not need that site assignment. Anyway, regardless, it doesn't matter what date you use to calculate the start of construction deadline, taking into account the 4 years of the Permit Extension Act and the 2 years to commence construction. Okay, so that's 6 years. Permit Extension Act gives you 4, and the regulation gives you 2. So you add those together, you get 6 years. If you calculate 6 years from the date that the zoning land court judgment came down, even well before the air plan approval, you get into a time frame right smack dab in the COVID extension. I can give you a table that shows those dates, but the bottom line is that any way you crunch the numbers, if you give effect to the Permit Extension Act and if you give effect to the 2 years to commence construction, Palmer Renewable is not late.
So let me ask you, when did the 2-year begin, taking into account, assuming for the sake of argument what you're saying, when did the 2-year period begin?
Let me look at that. I have a table here that there's so many different dates, it's sort of hard to keep track of them. So the land court judgment came down on August 27, 2014. This is the least advantageous to Palmer Renewable, by the way. Okay, this is not the most advantageous. I just decided to go to the least advantageous. In that the plan approval was in existence on June 30, 2011. June 30, 2011 is within the so-called tolling period under the Permit Extension Act. Okay, a permit in existence is extended 4 years.
That would take it to 2015?
No, it takes you out to 2018.
In 2011. Did you say that the Permit Extension Act then? Maybe I'm misunderstanding you. So the permit, although it wasn't final until 2012, when did the permit extension 4 years begin?
It began when the land court decision came down at the very earliest.
Okay, all right.
That doesn't give us the benefit of the fact that we were subjected to other litigation challenging the air plan approval. And
I get it. Yep.
Okay. So that means that the 2-year period would have started in August 27th, 2018. Okay. Which gets you, if you add 2 years to that, that's August 27th, 2020. Well, the COVID Extension Act came into effect on March 10th, 2020. Anything after March 10th, 2020 was extended and still is, because the state of emergency is still in effect. Well, anyway, your order is in effect. You've ordered Palmer not to proceed with construction. So the bottom line was the project can't move forward. So let's go back to the Permit Extension Act for a moment. Mr. Fallon argues that the permit didn't exist because it was under an adjudicatory appeal, right? Well, the statute says that a permit in effect or existence, it's disjunctive. So he may well be correct that an airplane approval that is under appeal in the adjudicatory hearing process is not, quote, in effect, but there's no question that the permit existed. I mean, it's not like it disappeared off the map. In fact, in this very case, Mr. Simpson, Mark Simpson of the department's Western Regional Office, attached to his pre-filed testimony what he called the final permit. Well, that document is dated June 30, 2011. So I hope I helped you with the dates.
Yes. Anything you wanted to add with respect to the issue on the 2-year period? because I was going to ask Mr. Fallon the next set of questions that I had.
Well, you asked earlier whether or not the department, what the basis for the department's determination that Palmer had not, quote, commenced construction, right?
Right.
And he argued that the facts are absolutely crystal clear. And I wanted to address that.
Okay.
And I also wanted to address the so-called fairness question that you asked. I've couched it as basically legality, but there is a fairness element of this. And the case law is very clear that where you can't practically proceed under a permit, the deadlines are extended or told. And I've cited those cases. I'm not going to give you the names because it'll slow us all down.
Based on my understanding of a basic zoning law, that I believe to be the case. But I understand.
There's no clear distinction between under zoning statute that says, you've got X number of months or X number of days to start construction versus the DEP rule, which essentially uses the same verbiage, right? So I think there's really you'd have to find a good reason to distinguish between the DEP and the zoning cases to say, well, that rule doesn't apply here. And I don't see the foundation for that having been laid here. There's no real meaningful difference. Let's go to the regulatory language talks about commencement shall be deemed to have constructed if you've done permanent construction on the emissions unit itself, right? Our argument is that that's not exhaustive. That's not the only way in which one can, quote, commence construction. As you will see from the documents that have been filed, PRE spent millions of dollars on project development, not just soft costs. And you were out there, you went to the site, you saw the property that they acquired, you saw where they tore down a building, you saw where they constructed a road, and all in making it possible to move the asphalt pile and to put the plant where the plant belonged. That was spent, not in some instances, notwithstanding the fact that the project was still under somewhat a variety of different kinds of attack, but essentially started when after not all of it started after, but much of the money had been spent, even though negotiations were going on. The dollars, and you've got those in the papers, came after the Superior Court judgment. After the expiration of the appeal period on the Superior Court judgment. So they did go forward with a substantial amount of work. And if you go back to sort of the fairness argument, why didn't they do it earlier? Mr. Fallon says, oh, well, it was just a decision that they made not to do this. Read Mr. Gatto's affidavit. You can't get financing for a project that's under this kind of assault. They had it, but they lost it. In fact, this is not the first time that Palmer Renewable has been through this. This happened back to the same project in 2010 when the department revoked the earlier sets of permits. It had all the financing, it had power purchase agreements lined up, and it had the basic ingredient to proceed with the development, and the department pulled both the draft air plan approval for that earlier iteration of the project and the BUD, and they had to start all over again. So the bottom line is as a matter of law, they couldn't have proceeded with the project, and as a matter of practicality, they couldn't have. So in fairness, in addition to the legal issue, you've got to give effect to those appeals and the litigation on their ability to proceed. It wasn't a matter of choice. This is a concerted strategy of the organizations that oppose this project was to kill it by delay.
Anything you wanted to add? Anything else you wanted to add on the 2-year question before I go to
Sounds
Mr.
like you have something in mind you want me to address, and I'm not sure what I'm missing.
No, I think you covered what I wanted to ask.
Well, I will wait. I'll add one thing.
Yeah.
We filed a motion to strike certain aspects of the testimony, and I didn't want to leave that out. There's a statement in Mr. Simpson's, who's a fine gentleman, that he believed, based on conversations with folks in the office, that the reason behind the 2-year rule was that they didn't want permits to become stale.
Mhm.
And that becomes like a law of the case somehow. And it's repeated by other people and it's used in the Commonwealth's papers. Well, there's no basis for that. It's just a conversation around the office.
Mhm.
I don't know what the basis for the 2-year rule is, but I don't think we should be using that particular
Right.
testimony as the foundation for the rule.
Thank you, Mr. Mackey. Mr. Fallon, assuming for the sake of argument, and again, my questions are not an indication of where I stand on the issues, but assuming for the sake of argument that the department did correctly determine that that construction of the proposed facility did not commence within the 2-year period under 310 CMR 7.023K, as the department contends, assuming that determination was correct. Tell me why Mass DEP believes that it properly exercised its discretion to revoke, because wouldn't you agree, and Mr. Mackey pointed out, I believe in the last brief that was filed, that I believe the condition 46 of the actual permit gave DEP, Mass DEP, various options, including if the permit holder was not in compliance, that under condition 46, DEP had various options, revocation, suspension, modification. So DEP opted for the revocation. So in your answer, if you could explain why it went the revocation route versus the suspension route, and if there is any a particular reason why the suspension route would not have been the proper option, I'd appreciate if you would help me, if you would help explain or tell me what the DEP's rationale was.
Certainly, and thank you for asking that question. Condition 46, I believe that's the condition in the permit, really is referring to not only the revocation rule, but the department's ability to conduct enforcement against an existing facility that may or may not be compliant. But that is really reflecting the rule of revocation 7023K, whether or not construction commenced within the 2-year period.
So not to interrupt you, so that I understand, are you saying to me, so that I understand, that condition 46 really applies to a situation where the facility has been built and that as a result of an inspection or otherwise, that's when that provision kicks in?
That the plain language of the regulation that condition refers to activity being taking place at the site. Activity, we interpret that as being emissions, improper use of the facility, things of that sort. It is just not applicable to this situation because the real problem here is a lack of activity for almost 10 years, a lack of anything for almost 10 years. And the reason why the revocation is appropriate rather than a suspension or that type of action, or I think there was a suggestion of a consent order, which I say in of itself is a mission of a violation of the regs. The reason why revocation is necessary are severalfold. First, revocation is necessary under the current environmental justice policy, which was not in existence at the time this permit issued. Under the current policy, there are much more robust requirements for outreach to the environmental justice community. And it's important to look at the public involvement plans the department currently has in order to outreach to those communities. And I think it is clear, it's just unequivocal that nearly 10 years of non-involvement with the environmental justice community is just inappropriate. It's almost like people are saying, that's good enough for those people, that's good.
All right, so let me understand then. You're saying that the EJ policy in existence then, and now as revised as recently as June of 2021 to reflect the recent enactments by the legislature earlier this spring regarding climate change and EJ populations, that the EJ policy compelled DEP to revoke the air permit. Is that what you're saying?
It is one of the grounds for the revocation since
But
we are
compelled, are you saying, because I thought you say that it really, the EJ policy imposed this real requirement on the department to revoke. And the EJ policy, I've read, as you know, the 2002, the 2017, and now the 2021. I don't recall there being any explicit provision mandating the revocation of a permit. What I recall is that, and we'll deal with the current version because that's what governs, is that EJ, environmental justice, has to be an integral part of every EA agency's regulatory actions. And that basically, the way I interpret the policy is that when the department, in this case, applying the air permit regulations, has to apply them in a manner that makes environmental justice an integral part of the regulatory process. And if the department decides, like it did here, to revoke, that's under the air permit regulations, and that the EJ policy gives a further basis for doing so. But it's not because the EJ policy has a provision that mandates revocation, right?
No, that is absolutely correct. There is no mandatory basis in the EJ policy. And if I misspoke, I correct that. What I was trying to articulate was that the EJ policy requires us, the department, to engage the EJ community in meaningful involvement with projects that the department approves or denies. And that the passage of time here, it's nearly 10 years since we heard from this community and had any involvement with them, that effectively has silenced this community. The EJ population in the Springfield community has not been heard from. And
now, let me ask you this question. Again, I apologize for interrupting, but this is how I learn and I understand. All right, I talked about earlier about condition 46 in the permit about having options of revocation, suspension, or modification. And you made a plausible argument that really governs if the structure is operating and there's something inappropriate or in violation of the permit, that comes into play. But with respect to what options Mass DEP had with respect to what it was going to do after, assuming, for argument's sake, it made the correct determination that PRE did not commence the construction within the required 2-year period. Assuming for the sake of argument that determination was correct, revocation wasn't the only option available to the department, right?
Well,
the department, Mass DEP, could have suspended the permit, right?
With all due respect, I suppose we could have abrogated our responsibility under the EJ policy and not done anything. Revocation was the only option.
No. I'm not saying. I'm going by the assuming, for sake of argument, that the DEP made the correct determination that PRE didn't commence the construction within the 2-year period required by that air permit regulation that we've been talking about. I am not advocating under the assumption that, DEP made the correct determination in the 2-year period, that DEP shouldn't have done anything. What I'm getting at is, wasn't suspension of the permit within the range of options that DEP had here?
With all due respect, no, because what we are seeking are new public comments from the community, in particular, new comments from the environmental justice community. We're seeking engagement, meaningful engagement, as required under the 2017 policy.
But couldn't you do that anyway if you suspended the permit?
There's no.
But what I have in mind, and maybe I'm, missing something. Couldn't DEP, and I'm playing devil's advocate and trying to understand the positions here. Again, it's not a statement of how I feel. It's basically feeling out the parameters here of the type of action that DEP could have taken. That's all. And so if DEP suspended the permit, correct me if I'm wrong, the construction of the facility can't go forward, right? If it suspended the permit, right?
If it suspended the permit, yes, that
Okay.
would be correct.
And within that context, DEP could have done all the things that you just mentioned, that the EJ policy, the current version, and the previous version did have all those requirements about public participation. The current one expands or elaborates more as to what that is all about. So what I'm saying is, couldn't you have done all that? Or excuse me, couldn't have Mass DEP done all that if it had suspended the permit?
Thank you. And again, I just wish to re-emphasize my argument that regulation on suspension really is not applicable here, since it only applies to activities. However, that being an option, if the department went outside of its regulatory authority, suspended this permit, and then kind of invented out of thin air a new public involvement process that was outside of the regular regulatory process, that would be arbitrary and capricious. That would be outside.
Well, I don't think it would be inventing anything. I think, unless, Mr. Fallon, I'm missing something, it's basically you or the department continuing with the processes it has in place. What I'm saying is, what I'm getting at is revocation basically says no more permit, gone. Correct. And so suspension of permit means it's not gone. Might be gone down the road, or maybe reinstituted based on obtaining new information, because I can understand where the department is coming from. Again, assuming for the sake of argument, 2-year period to construct wasn't complied with. I can understand, okay, 10 years have gone by. There has been a certainly renewed focus on environmental justice, certainly issues about best available control technology backed, which is a big part of air permitting, that there is more information now about whether or not facilities of the type authorized by this permit really are appropriate alternative energy facility. You know, issues of policy, okay? And of course, the fact that we've had a COVID-19 pandemic the last year and a half that doesn't seem to be abating yet. Hopefully it will, and has had undisputably an impact on communities, many communities of color that have been disproportionately impacted by COVID. So when I say instead of revocation and suspension, I am not in any way saying DEP should have done nothing. What I'm saying is the agency had this range of options, including doing nothing, all right? All right, so that's off the table. And so you have suspension and revocation. And, you know, I'm trying to get at, well, why wouldn't suspension have been the way to go?
And again, and I apologize for repeating myself, but suspension is appropriate where there's a violation of regulation to bring the facility back into compliance, simply because if there's something they're not doing correct. That regulation, 310 CMR 7.153, gives us the authority to suspend, say you're going to stop emitting, no more emissions. You need to correct A, B, C, and D, and you're done.
Yeah, but that and you have made, and I said before, you have made a plausible argument that the term suspension, as appearing in condition 46 of the air permit, is for the situation where the facility has been built, it's operating, and something in violation of the permit is occurring. I get that. However, Here, as I said before, the way I see how this occurred, or how, based on the facts that DEP has advocated, is that DEP did an investigation or studied whether or not PRE commenced construction within the 2-year period as required by the air permit regulation, 310 CMR 7.023K. It made a determination that it hadn't. And then it had, and as a result of that determination, it had a range of options of how to proceed, right? Am I right?
Our position is we
Revocation wasn't mandatory, Mr. Fallon, right?
We agree, but that was the only option in order to accomplish the goals that we seek to accomplish here today.
So you're basically saying, if I'm understanding correctly, that DEP chose revocation because it made a judgment that revocation was the best option to exercise under the circumstances.
The best option, in all due respect, we feel it was the only option in order to reinitiate the permitting process, address the issues of back, changes in technology, and most importantly, to give the contemporary members of the environmental justice community an opportunity to come in where they should come in at the beginning of the permitting process. Revocation is appropriate. Suspension would be kind of putting the EJ community back, not giving them a full opportunity to come in as required under a new application.
I don't know. Again, unless I'm missing something, I don't read the EJ policy that way, Mr. Fallon. I think perhaps, and again, I mean, I don't want to sound repetitive either, but I'm just trying to basically get a sense of how the department evaluated its options. So like I said, the department made a determination that PRE did not comply with that 2-year construction requirement. That's what I'll call it for the sake of being, brief on it, all right? And so as a result of making that determination, DEP had various options available to it, because that goes all to discretion, right? Because the fact that a permit holder hasn't complied with that 2-year requirement doesn't mean that the permit holder's permit is automatically revoked, right? Would you agree with me?
Yes, that's correct.
Okay, so therefore, upon making a determination that the regulation regarding the 2-year construction requirement not having been complied with, Mass DEP had available to it, in accordance with its discretion, various options, right? And those included revocation, suspension, or doing nothing.
I agree that revocation and doing nothing were the two options. Suspension is not applicable to a non-existent facility.
Okay, I understand. And so tell me again why DEP believed revocation was the best option.
Well, it's in the first instance, it's highly unusual to have a nearly 10-year-old air permit. These facilities get built usually within a very short time of the issuance of the final plan approval, even if a Superior Court action is commenced. This permit is over 10 years old, and the department provided a great deal of evidence as to the purpose of 7023K. The reason why it's there is because the AIR program in particular has many changes that happen inside of its scientific and technology aspects. So BACT, we've never said this permit will not meet BACT, but BACT may be modified by some new technological innovation that may have occurred in the past 10 years. Also, the other reason is the air in Springfield, as we admit, has improved, but it has changed. And that may change the modeling aspect of the permit. And most importantly of all is the real desire and responsibility of the department to actively engage the current members of the EJ community with this process. Suspension would not allow us to do that. Revocation.
Now, stop
allows-
right there. Stop right there. Tell me why suspension would not have allowed you to do that, because I'm having difficulty understanding that. Tell me why wouldn't suspension have allowed you to do that? Because the way I understand suspension means the air permit that was issued is now suspended, can't be acted upon by PRE. And the reason why we're suspending it is for all the reasons you just articulated for why the department opted for revocation. It's been 10 years. There's new information about this type of facility. There are more statistics regarding the health of the Springfield community, the community in which this facility would be located. And what I'm saying is I'm having difficulty understanding why that could not have done in accordance with the EJ policy, including having community involvement in the discussion of these issues, why that could not have been done in a suspension context. I have to be honest with you, I'm having difficulty understanding the department's position on that.
So in the way you are couching those terms, Officer Giorlandino, you're making it seem like a distinction without a difference between revocation and suspension, and they are absolutely different activities by the government.
Well, tell me, so enlighten me, Mr. Fallon.
Yes.
I mean, that's what I want to know. Enlighten me.
So the purpose of suspension is to get a facility back into compliance, a non-compliant facility with actual violations happening from the emission unit. Revocation set in our testimony, that my testimony supports, revocation comes in this instance, because this permit is stale, it's old, it's 10 years old. We need to start afresh, to start new for back determination, air modeling, and most importantly, for input from the contemporary members of the EJ community. If we went ahead with suspension, I believe we would be here today, and the argument would be that the department acted in an arbitrary and capricious manner by invoking the suspension because there is no activity for us to engage in enforcement against. Here, in fairness to PRE, they can come back and reapply, and the process would not be all that different from a suspension process, but the department believes suspension is not available to us because there's nothing happening at this site. There's no activity for us to claim is a violation of a permit condition. And in addition, we believe the best way to address all the concerns that we put in the revocation order, in our testimony, and in our briefs is to start anew, to go through this process. And we have never said PRE would not get a permit by going through this process, but we have consistently said it could be modified by current scientific conditions, and in particular, by comments from the contemporary members of the environmental justice community.
Well, can you tell me how this situation is different than in Brockton Power, where the initial air permit has gone through various variations during the pendency of the appeal, which I'm presiding over for 6 years now? I mean, there have been changes made to the initial permit. Where I'm getting at, Mr. Fallon, is again, I'm having difficulty. I'll take a look at it some more, and I want to hear from Mr. Mackey, obviously, on this issue. But I'm having difficulty understanding the department's argument on suspension. But thank you. I understand where you're coming from. Mr. Mackey, so now the question goes to you. The initial question I posed was to Mr. Fallon, as you recall, was assuming for the sake of argument, again, haven't made a decision, no ruling at all. Assuming for the sake of argument that DEP made the correct determination that PRE did not commence construction within the required 2-year period of 310 CMR 7.023K. Tell me why PRE believes that revoking the permit was an abuse of the department's discretion. And by asking that question, again, it's not a statement of where I'm coming out on it. It's I'd like to learn more about PRE's position of why it believes that this was an abuse of discretion by the department, and including a discussion of the range of options that PRE believes would have been available to the department as a result of having made that determination on the 2-year period. Am I being clear? I know I said a lot.
Thank
there.
you.
Okay.
I'll try to keep some boundaries around my response to that because it's a pretty big question. Let's start with the range of options and sort of a little bit of a history on that. You may recall that there was a letter dated, I think, December 24th, 2020, I guess a Christmas Eve gift to Palmer Renewable, signed by Senators Mackey and Warren, asking the department to suspend Palmer's permits. So apparently they were thinking along the same lines that you've been discussing with Mr. Fallon. Palmer Renewable responded to that by saying, we don't think that's justified for a variety of different reasons, many of which we've talked about already today, but also attempted to open up a dialogue with the department with regard to what would be appropriate. There were calls with the commissioner's office, as you know, it's in the papers, and Mr. Gorski, who signed the revocation order, was involved in that phone call. In our letters, we argued that there must be an alternative way to approach this. Could you send us a request for information, for example, under the air regulations? So from the very outset, and meanwhile, before all of that happened, there had been communication between Mr. Gatto, Dr. Gatto, who is the principal at one of the principals at Palmer Renewable, and David Howland of the Western Regional Office. There's a little bit of dispute about what the substance of those conversations were, but there certainly were. There was back and forth. So the department had plenty of opportunities to approach Palmer Renewable and say, hey guys, we need to do something about this. And instead, what we got was a revocation order, the most extreme thing that could have happened under the circumstances. And that revocation order laid out a number of different bases upon which revocation was justified. The paramount one being the environmental justice concern, at least based on my reading of that letter. And then the department has filed its pre-filed testimony, it's made its arguments, it's filed rebuttal testimony. And the case seems to boil down to the EJ policy, that there was a 2002 EJ policy. Let me go back. I'm getting off the suspension versus other suspension, revocation. A revocation takes your permit away, right? You've got nothing left. Everything else that depends on revocation is now dead in the water. For example, Palmer Renewable had negotiated power purchase agreements with 8 municipalities to purchase this power. Those were of relatively recent origin because it was impossible to negotiate power purchase agreements when your airplane appeal was under appeal. Those are dead now. Permit's been taken away. Perhaps suspension would have been different because it would have been able to say, listen, we're engaged with the process with the department under which we're trying to justify the continued existence of the permit in light of the concerns about the EJ community's input. But we'll be, we're good to go. I don't know if that would have worked necessarily, but at least it would have been an option. There is a continuum of enforcement. This is an enforcement case. You've decided that already in the very first rulings in order that you issued. Enforcement doesn't necessarily call for the death penalty. Case law that we've cited on the standard of review says there has to be a rational basis. But the language surrounding rational basis, especially in the context of equal protection arguments, and I'll get to that later on if you want to. And we're not claiming racial discrimination. We're just claiming plain old disparate treatment of Palmer Renewable versus similarly situated other projects.
So let me, although I'm going to have a separate question regarding that claim, because I want to really focus on, this suspension revocation issue, the options first. But so if I understood you correctly, PRE is not making a racial discrimination claim, but a disparate treatment claim under the Equal Protection Clause.
Yes, basically, the Equal Protection Clause that similarly situated parties should be treated similarly, and if there has to be a rational government basis for treating people differently. So
are you
so in
claiming
for
class
instance,
of one? Is PRE claiming class of one status? Because that's an equal protection claim that the Supreme Court has recognized.
I'm not sure what is meant by that. All I can tell you is the way I understand it is that
Okay.
that we're located in the vicinity of or near an environmental justice community, and as a result of that, we're being treated differently than if we weren't.
All right, so we'll get back to that later. Now to finish your thoughts about the option that DEP chose, which was revocation here.
Right.
I've
seen administrative consent orders entered into by the department with applicants for projects that authorize all kinds of stuff that is not spelled out squarely in the regulation. In some instances, it's something, if you read the regulations, you say you can't do that. So there's no reason why the department and Palmer Renewable couldn't have fashioned a remedy here that would have allowed Palmer to not be dead.
And that would have included, would you agree that could have included, as required by the EJ policy, the various stakeholder groups or EJ community representatives within those discussions?
It could have. I'm not conceding that the EJ community has been shut out.
No, I'm not going to say shut out, but be collaborative, to be part of the discussion.
Let me talk
that's
about
a judgment call.
Let me talk about that for a moment. Okay, can I just for the purposes of the fact that people are watching this on YouTube. Back when Palmer Renewable applied for the original air plan approval, it was not subject to the 2002 EJ policy because it was not a mandatory EIR. Okay. But Palmer Renewable voluntarily complied with the EJ policy by publishing the notice of the draft air permit in Spanish in the El Pueblo Latino magazine. It offered to provide people a copy of the draft air plan approval in Spanish. The department held a public hearing, which was not necessary, at least not mandated under the regulations for a non-major comprehensive plan approval. All of the environmental justice advocates in the city of Springfield were present at that hearing. In particular, there's an organization there called the Rise for Social Justice. There was another organization there called Stop Toxic Incinerator.
Not to interrupt you, Mr. Mackey, but wasn't that 10 years ago?
Yeah, those parties were parties to the appeal. You know when the appeal was resolved? The Superior Court judgment in the air plan approval came down in January 3rd of 2017. That's not 10 years ago.
Okay. So they basically have been involved. Your position is
there was an extensive amount. The complaint here is, we haven't engaged with the EJ community, I guess, in the past 4 years. Well, what if the project was already operating? What would you be able to, under the EJ policy, to say, you know what, we think people are complaining a lot, so why don't we just reopen the permit and let them get another shot at this? Okay. I mean, there are power plants operating across the United States that are far, far behind the current standards, but because they're grandfathered or whatever, allowing this as the basis of essentially saying, we're just not going to let this go forward, it seems to be disproportionate to the remedy that's sought to be achieved here. Okay,
and so to wrap up this segment of the questioning that I have. Again, assuming for the sake of argument, the department made the correct determination that the 2-year period of 310 CMR 7.023K wasn't complied with by PRE, what option should the department have taken instead of revocation?
Well, I think that the department, I think there's a wide range of things that they could have done. They certainly, first of all, could have done nothing. It was within their discretion to have done nothing. The department, the regulation doesn't automatically call for revocation of a permit. It just says may. So doing nothing is not a sin, right? In many cases, like you do a Superfund a remedy evaluation, the first thing is the no further action alternative. So I think that under those circumstances, if they had fairly evaluated the circumstances, they could have simply said, we don't need to do anything. We provided the department what was in effect a back analysis. We provided information with regard to the air quality, the improvements in the air quality in the city of Springfield before the decision was issued. There really isn't anything under the air regulations in terms of aside from the sheer age of the permit alone, okay, just dates. There's no other thing that compels revocation. Nothing. We produced testimony on all of those points, and it has not been refuted. The department has the burden of proof in this case to demonstrate, for example, that it's no longer backed. They have the burden to demonstrate that the air quality in Springfield is worse. None of that has been done. We have uncontroverted testimony on the health basis that were cited. It was very loosey-goosey. Well, we have this asthma capitals report. We produced testimony showing that the asthma conditions in Springfield are better now than they were when the permit was issued. Uncontroverted. So when you boil it all down, it comes down to essentially, we would like to give the minority community, the EJ community, an opportunity to be heard. And my question is that call for revocation of the permit? I don't buy that the department's hands were tied. It only had one option and everything else was unlawful. We've got to do the worst thing to you because everything else we can't do. I just don't buy it.
Thank you for articulating PRE's position on that issue. What I want to go to now is the last issue, and that is whether I should allow PRE to assert a new disparate impact claim based on the Equal Protection Clause of the 14th Amendment of the United States Constitution and the Equal Protection Clause of the Massachusetts Constitution. Mr. Fallon, the department has made its position clear in its supplemental brief that I shouldn't allow that claim to go forward. Could you help me explain further the department's position on that?
Well, yes, thank you. If you're going to bring an issue this late in the adjudication, you need to show good cause for why you couldn't bring it up earlier. This is not new. There's no material change in facts that occurred here. Actually, most of the facts were agreed upon by the parties in this matter. There's been no change in the law that we could find that would make this a hidden claim that they could not have made in their initial notice of claim. So in fairness to the parties, in fairness to the department, if this is a real claim and a real purposeful matter to bring before us, they could have done it at the outset of the case. We really see this as an action to try to change the standard of review that this forum is required to hold. We say, and I think for a while, PRE said, the standard review we're held to is a rational basis test. What we've heard from PRE is that something else should be used, but we have not seen articulated what that standard should be and what law it's based upon. So therefore, it's a baseless claim. We think the reason why it's brought up at this late date is because they feel that the rational basis test is clearly in our favor, and they're trying to change the long-standing standard that OEDR and the appeals courts of the Commonwealth use in reviewing agency decisions, which is the rational basis test. And so for all those reasons, it's just too late, and there's not grounds for them. There's certainly not good cause to allow these issues in.
Question, Mr. Fallon. Again, these are all devil's advocate, not a reflection of where I stand. I believe I have the discretion to treat PRE's assertion of the disparate impact claim, that I could treat it using my discretion as a presiding officer as a request to reopen the hearing. Because as you know, under the adjudicatory proceeding rules, at any time before a final decision is issued in an administrative appeal, the presiding officer can reopen the hearing. And in this case, I realized that both PRE and Mass DEP waived the hearing. So really, it's more reopening the evidentiary record. That's more accurate description, although it's in essence a reopening of a hearing that was waived. You understand where I'm coming from,
Yes, I
right?
do. Yes.
Okay. And so would it be prudent for me to reopen the hearing or the record to basically allow cross-examination of the parties' respective witnesses on this disparate impact claim? Or is there enough for me based on the record that's before me to make, assuming I let the claim in, okay, to make a determination on it?
Thank you. Assuming Officer Giorlandino, you let this claim go in despite its late filing, we believe it's a pure question of law that can be ruled upon based on the arguments made by the parties and the evidence in the record. There really are no factual disputes in this matter between PRE and the department, and there certainly is no evidence anywhere, even a hint of any type of racial discrimination or other types of disparate impact claim that we can see in the department, and as we argued in our briefs. So if it is something that you do deem appropriate to be allowed in as an issue for this adjudication, the department's position is that it can be ruled on the record, the administrative record currently before OADR.
So basically, Bass DEP's position is that if I let the claim go forward at this time, and I will say it is a late in the proceedings for the claim to have been asserted. There's no question about that. That I don't need to reopen the evidentiary record, that what's before me is enough to decide the issue if I decide to let it go forward, right? Is that what you said?
Yes.
Okay. Now, Mr. Mackey, I'll turn to you. Could you help me? Could you explain some more why I should let PRE assert this disparate impact claim late in the process? And I'll focus on the following undisputed facts in the record. PRE's appeal notice that was filed in April, which was 6 months ago, did not assert a disparate impact or racial discrimination claim. I established the issues for resolution or adjudication in the appeal early on. The first thing I did in this, actually the second thing, the first one was a briefing order to respond to PRE's motion to stay the revocation order. And then I issued rulings in order, the comprehensive one, that basically set the appeal resolution schedule in the case. And the issues were whether, DEP correctly determined the 2-year issue, and if so, whether or not it abused its discretion. And so the claim was raised for the first time in September after the evidentiary record had closed, and both sides had agreed to waive the adjudicatory hearing. And so with that backdrop, could you help me explain why I should allow PRE's disparate impact claim to proceed?
Sure, I'll do that. I've got cases that we cited in our final brief.
Yes. Yeah.
That basically say that when the issue is not fully formed at earlier stages in the proceeding, the judge has the discretion to allow the issue to be raised. And that's basically what we're relying on, in addition to the fact that then we think that constitutes good cause. And if you sort of go through the iterative process of how this has unfolded between the our original claim for an adjudicatory hearing and then the back and forth pre-filed testimony and briefing, the case got whittled down from BAT and health impacts and air quality in Springfield, whittled down after reviewing all the testimony to essentially the EJ policy. And that's how you started out today, basically saying, that's really what we're talking about. And at that point, it became apparent to me as the attorney for Palmer Renewable that we really had to take an even deeper look into that policy, even though we had briefed it adequately and we had provided a lot of testimony on what Palmer Renewable had done to comply with the 2002 EJ policy. And there was a substantial amount of back and forth between the rebuttal testimony about all of the elements of the EJ policy that the department says apply now, the 2017 policy, and how they might be different from 2002 really boils down to one thing, which is a public involvement plan, how Palmer Renewable had effectively complied with that. So we got to the point where I was looking at it and I was saying, you know, this is a new area, right? This is the first time an EJ policy has ever been used, as far as I know, to affect the substantive outcome of a case. And there's literature on that, which to be honest, I was not aware of before this case got to the point where we were really focused on that. So it really evolved as sort of bubbled to the surface as a very significant question. Now, I'll admit to taking a complete misfire on the strict scrutiny analysis. That's just not right. That depends on the whether or not the plaintiff, in this case Palmer Renewable, is being subjected to some kind of racial discrimination or a reverse discrimination, sort of the Mackey case and all that line of cases. There's also literature on that, but I don't want to go there because we're not alleging that. We're simply saying that it's a straightforward equal protection claim that deals not with a fundamental right under the Massachusetts Constitution, because the property rights and the permit are not fundamental rights under the Mass Constitution, as far as I know, and we're not a suspect classification. So Mr. Fallon is correct that it does affect. So our argument why you should allow it in and why we think there's good cause is because the issue wasn't really fully developed. It wasn't front and center. I'd also argue that it really doesn't hurt anybody to take it into account now, and it probably completes the record to have it adjudicated for purposes of appeal. It's a pretty significant issue. I don't think the equal protection argument is that meaningful or significant to the case. It doesn't really change much. You'll see that there are cases, Massachusetts cases we cite, that talk about the fact that the equal protection analysis is essentially a rational basis test. But it does incorporate some language with regard to the sort of the proportionality of the interest to be protected by the government action and the rights of the party, which are very similar to some of the stuff that you cited in the Kane-Built case. I think it's Kane-Built. I think it's a Presiding Officer Palace it might be Metallic's case. They do talk about proportionality to some extent. So I think we're really talking about the same standard, maybe slightly different. And I agree with Mr. Fallon, there are no facts at issue here. The bottom line is that Palmer Renewable Energy is being treated one way because it's near an environmental justice community, and if it weren't, it would be treated another way. And so it's a corporation; it can't claim racial discrimination. It supports the EJ policy. There's no. I think everybody's been pretty good about making sure that we don't go up in arms on this. I do take responsibility for having raised the strict scrutiny argument. That was an error, but there nevertheless does constitute another claim that should be considered. It's been fully briefed. It's not fact dependent. And I think you can, in your discretion, do it. Certainly don't need to reopen the hearing. We don't need any new witnesses or testimony. There's nothing unique about that. I think when you get right down to it, I guess what you would say is if we were located somewhere that was not within an EJ community where the policy didn't apply, the department would have had to rely on other grounds.
And so to recap or to summarize your position, and correct me if I'm not summarizing it correctly, PRE is not claiming, is not making a racial discrimination claim against the department, right?
Correct. We never actually alleged that we were per se. We were saying that the policy is based on racial distinctions, right? But not of the applicant, of the community, which is sort of an interesting, theoretical construct that raised the whole question of strict scrutiny, but it doesn't actually apply because of the nature of pre.
And so if it's not making a racial discrimination claim, it's making a disparate impact claim saying if the proposed facility was going to be located in an area that wasn't an EJ community, would have been treated differently.
Correct.
All right. Now, isn't it true that the Commonwealth, through Mass DEP, has a compelling state interest? And I'm not using those terms to mix strict scrutiny, because I think it applies to rational basis as well, okay? Assuming I let this claim go forward, wouldn't you agree that in making environmental permitting decisions, which would include revoking a permit, that the Commonwealth, through Mass DEP, has a compelling governmental interest to prevent further harm to the health of a particular community? And isn't that a rational basis? Now, I'm not getting into whether or not there's evidence in the record, but I'm just saying, couldn't that be a valid basis for a racial classification in an EJ policy? That communities of color have been, there have been scientific studies to show that their health compromise between asthma and increased heart disease. And isn't there a compelling state interest or governmental interest to prevent exacerbating such problems? Would you agree with me that that's a compelling state interest that could justify a racial classification? And by the way, the EJ policy, as I read it, it's not just, well, the definition of EJ is not based on minority status. It includes income, it includes the alternative of English isolated or limited English proficiency. So that's my question.
Well, I think that's a good hypothetical. We did spell out in our earlier brief how the Supreme Court has handled such type of corrective policies, and right?
Yeah.
And there certainly is, has been found that can be a compelling government interest under the right circumstances. So I think that's entirely within the realm of possibility. We're not challenging that here. Certainly, I think the department not only has the ability, but the obligation to protect the public health of its citizens from deleterious air pollution and the health impacts. And certainly the Climate Roadmap Act adds to that. We're not contesting any of that. But no one in this case has actually claimed that those impacts are going to occur or as a result of this project. In fact, the department defended this permit through 2017 against exactly those claims.
Based on the NACs. And the NACs were a big part of it, wasn't the National Air Ambient Quality Standards?
Well, it went beyond that. There were claims that this was going to be a condition of air pollution and that the Springfield community was especially sensitive to the impacts of that.
Right.
And those there were claims in the original adjudicatory proceeding of violations of the federal EJ provisions. So this issue has been litigated, not the foundation of whether an EJ policy is legitimately enforceable, but simply the question of whether or not the Springfield community was going to be disproportionately impacted by this project was fully litigated and resolved just 4 years ago.
Thank you, Mr. Mackey. I'm going to conclude our session today by posing the same question I just asked you to Mr. Fallon, because I think it's important for DEP to articulate its position officially on that question. So, Mr. Fallon, the question that I posed to Mr. Mackey was, wouldn't you agree that in making environmental permitting decisions, the Commonwealth of Massachusetts, through Mass DEP, has a compelling governmental interest to prevent further harm to the health or to prevent from making worse health problems of particular communities, let's say communities of color, where there have been documented health issues, asthma, heart problems, respiratory issues? Wouldn't you agree that the Mass DEP has, the Commonwealth through Mass DEP has such a compelling governmental interest?
Thank you, Officer Geraldino. And certainly, yes, there is a compelling state interest here. As Ms. Deneen Simpson's testimony sets out in great detail, the EJ community in the Commonwealth of Massachusetts has historically been subject to disproportionate adverse impacts from environmental permitting in the past, and EJ policy seeks to rectify that. And I wish to point out something that I think is very important, if I may, two issues here. The environmental justice policy is procedural. It's not substantive. This is a process to get the community involved and get information to the government on aspects of this project that will impact the unique aspects of the community. We have never said, and nor would we say, that there's any type of emission that would occur from this facility that would have an adverse health impact on the EJ community. We already litigated that, and the emissions are within the NACs and are within the state parameters. The EJ procedure is something that we need to put into place here through the revocation order because of the gross passage of time has effectively silenced the contemporary members of that community. So that procedure is what we're looking for in order to bring this community back up to speed on what's happening. And in addition, if I could just respond to a few arguments that were made, there is no requirement under 702(3)K that the department prove any violation of any permit condition whatsoever. It's a discretionary act on the part of the department, and our action has to have a rational basis. So we don't have to prove a violation of an emission standard. We don't have to prove a violation of a permit condition. We have to prove that we made the decision based on the information available to us. And that information, as set forth in the revocation order, was there are concerns. Springfield has bad air. We never said the air emissions from this unit would have any disparate adverse impact, but we said that's a concern. There's a concern that 10 years ago is the last time we got public comments from the EJ community. And there's a concern that there may be changes in scientific technology that will affect the back standards. So this wasn't a whittling down process. This wasn't eroding away to one issue. There are multiple issues that substantiate the department's rational basis for this decision. And the EJ procedure is one of the things that we feel we are obligated and responsible to allow the community to have input on this.
Thank you,
May I
Mr.
respond to
Fallon.
that? May I just respond to that?
I'll let you have the last word.
Thank you. I just wanted to point out that the basis for the revocation decision was concerns. Not that the project is violative or going to cause any public health impact. It's simply that they want to take comment, which as recently as January of 2017, those same organizations were litigating against the department on this very permit. And the department prevailed.
Thank you. Thank you, Mr. Mackey. Thank you, Mr. Fallon. It was, it's amazing when you're having fun, time goes by. We're almost 2 hours have gone. Yes, no, this is, I will tell you that this is a very important case. It has been well briefed. I have a big challenge ahead of me. We'll see where we go from here. Thank you very much for your efforts. And at this point, we will conclude our proceeding of the oral arguments, or closing arguments of the parties' counsel in the matter of Palmer Renewable Energy, LLC. Have a good rest of the afternoon. I bid you adieu. Take care.
Thank you very much.
Welcome.